Appeals is now in session.
Good morning and welcome to the Court of Appeals sitting in Jackson. I want to welcome everyone to our online hearing and let you know that we will conduct this hearing just as if we were in court, although you can continue seated. There's no reason to stand. You can continue arguing from your seats. This is a Western Section panel, including Judge Armstrong from Memphis, Judge McGee from Savannah, and I'm Judge Golden from Memphis. Is there anything we need to discuss before the hearing begins?
No, sir.
All right, you may call the case.
Jerry Moorehead et al. Versus Tennessee Farmers Mutual Insurance Company.
Good morning, Your Honors. My name is Eric Birch of the Coffee County Bar, and I represent Jerry and Deborah Moorehead in this appeal. The issue in this case is fairly straightforward. My clients were in an automobile accident in 2017 on May 29th. The case ran its course and we were set for trial, and shortly before trial we agreed to set a mediation which my clients attended. Also in attendance were the defendants, who were the Crabtrees, and the Mooreheads, my client's uninsured motorist company, was represented by Walter Nichols. He was present at the mediation as well. At the mediation, the facts show that the insurance companies, both the underlying insurance companies for the Crabtrees and the uninsured motorist company represented by Mr. Nichols, at the very beginning of the mediation, policy limits were tendered, $100,000 from each, from both the underlying insurance and the uninsured, underinsured motorist coverage. So we started from a floor at the mediation of $200,000. Subsequently, through the course of 5 or 6 hours, was Ms. Moorehead's testimony. The case eventually settled with the Crabtrees personally paying an additional $100,000 for a total settlement of $300,000. Over the course of the next 60 days or so, the Crabtrees paid their $100,000 personally. Their underlying insurance company paid $100,000. The only fly in the ointment, so to speak, was the uninsured motorist only paid $50,000.
Let me ask you, Mr. Birch, was Mr. Nichols there throughout this 5 or 6 hour mediation?
I can only assume that he was. I know he was there at the end of the mediation, and he signed the mediation agreement on behalf of Tennessee Farmers. So I wasn't in the same room as Mr. Nichols, but unless he went somewhere else, the mediation occurred in Winchester and Mr. Nichols' office is in Manchester. So I assumed that he was at the mediation the entire time.
I'm sorry, who's Todd Bob then?
Todd Bobo represented the underlying insurance company, which also happened to be Tennessee Farmers.
Okay.
And the Crabtrees personally were represented by counsel at the mediation as well. That would have been John Hill, who also testified at the motion to enforce the mediation agreement.
Okay.
You may proceed.
So I immediately contacted Mr. Nichols and said, we only received checks for $50,000, and the mediation agreement says Tennessee farmers, the uninsured motorists, would pay a total of $100,000. The language was "will pay," and that's what Mr. Nichols asserted, that Tennessee farmers had previously paid $50,000 under a med-pay provision of the insurance policy, the uninsured motorist insurance policy. I took the position that the mediation agreement, the $100,000 was for new money. Nothing was ever asserted about any sort of subrogation interest or some sort of set aside. The mediation agreement says Tennessee farmers will pay $100,000 to the Mooreheads. We agreed to disagree, and I filed the motion to enforce the mediation agreement. And that motion was denied by Judge Burke there in Moore County. And this appeal followed.
I'm sorry, who drafted the mediation agreement?
The mediation agreement was drafted by Judge Buddy Perry, retired circuit court judge from the 12th Judicial District, who set up his own office and primarily does mediations in cases here in southern Middle Tennessee. He drafted the agreement, and it was signed by all parties. Our position is that the mediation agreement is essentially a contract. In looking at contracts, we look at the clear language of what the contract says, and if that's clear and unambiguous, the contract language controls. And the contract language in this case, in this agreement, says Tennessee farmers will pay Deborah Moorehead $50,000. Tennessee farmers will pay $50,000 to Jerry Moorehead. I don't know how much clearer and unambiguous that language could be. So that's essentially our argument, that we look no further than that. And then the question becomes, did Mr. Nichols have either actual authority or apparent authority to bind Tennessee farmers to more than what the policy limits were in this case? I cited the case of Love versus Woods. That's a case out of the Eastern District. And in that case, similar facts, that the attorney for the insurance company agreed to settle a case for $100,000, and then came back later and found out that there was only $50,000 worth of coverage there. Now, Love versus Woods didn't get us all the way to the finish line, because it wasn't clear from the underlying case whether that attorney had agency authority to bind the underlying insurance company in that case. But this case is different, because Mr. Nichols was representing the actual insurance company, not just the insured by the insurance company. He was representing the actual company. He was the only representative from Tennessee Farmers who was present at the mediation. He signed the mediation agreement on behalf of Tennessee Farmers.
Let me ask you a question, Mr. Birch. I just want to make sure that I'm clear. Was there 100, 300,000 in uninsured motorists? Is that what the limits were?
That's correct.
So, do the monies that were agreed upon exceed the limits? Is that the concern? in other words, is it your position that Mr. Nichols, on behalf of Tennessee Farmers, agreed to an amount in excess of the coverage?
Well, the position they take is a provision from the insurance policy. There was a med pay payments that were made that totaled $50,000 a couple of years prior, back in 2017 and 2018. Tennessee Farmers Insurance made $50,000 worth of payments that was paid to medical providers and to my clients. So
is that considered part of the, under the policy, is that considered part of that 300,000 coverage?
Yes, Your Honor, it is.
All right. So I'm trying to understand, because I kept going back over this myself with the numbers, and I want to know what your position is on this. Is it your position that if you accept the fact that they paid each of your clients $25,000 under the med pay provisions of the policy, and you received the other monies from the defendants, and this additional $50,000, is there still coverage available under the policy, under the uninsured motorist policy?
There should have been, only in looking at the policy. Now, we weren't aware that policy, the monies that had been paid, would be considered under the policy at that time.
But that's your client's policy, right?
It is my client's policy, and they're bound by the policy ordinarily. The position I'm taking is Mr. Nichols had authority or apparent authority to enter into contracts, and at no point during the mediation process was anything ever mentioned about $50,000 having already been paid, that applied toward that $100,000. It's not contained in the mediation agreement.
Okay, I understand all that. I'm just trying to find out whether there's two things. One, if you take the med pay money that was paid under your policy into account, does that amount to the coverage, the full coverage under your policy?
Yes.
And secondly, would this additional $50,000, would that be in excess of the policy limits of your client's policy?
Yes.
All right. Thank you.
Mr. Birch, it's not because of the med pay that the limits have been achieved. Isn't it also because farmers paid the other 100,000? So you've got that language in the policy talking about payments by other companies. Isn't that why it equals the policy limits, not just because of the med pay payment? Correct.
Right. There was $200,000 in insurance company available. $100,000 of that came from the defendant's underlying insurance. And then $100,000 came from the plaintiff's uninsured/underinsured policy.
Right.
That's all the insurance that was available from insurance. I think I'm out of time, so.
All right.
I'm sorry, go ahead. Mr. Nichols, it's your time. You'll have your rebuttal, Mr. Birch.
Thank you, Your Honor.
Thank you, Your Honor. I'm not sure if I'm on or not. I'm still looking at Mr. Birch.
You're on, sir.
All right, sir. I'm Walter Nichols of the Coffee County Bar. I represent the unnamed defendant in this matter, Tennessee Farmers Mutual Insurance Company. They provided an insurance policy for the Mooreheads with uninsured motorists BI limits, bodily injury limits of $100,000, $300,000. It's our position that the policy's been fully complied with. In this case, the defendant, Crabtree's Insurance provided $50,000 per person. We multiply that by 2 for both the Mooreheads, or $100,000. We subtract that from the limits available under the uninsured motorist coverage. Subtract 25 from each, would leave we have the 100,000 uninsured motorists, 50,000 BI, 25,000 med pay per person, which in fact was paid at the request of their attorney, Eric Birch. He directly contacted Tennessee Farmers and had that done, and that was appropriate to do so. They had some medical bills that they needed paid, and that was done. The 25,000 med pay each, plus the 25,000 we have tendered in additional funds each, plus the 50,000 each bodily injury liability, satisfies the applicable limits under Tennessee Farmers Mutual Insurance Company policy that the Mooreheads carried. Our limits.
Let me ask you, Mr. Nichols.
Yes, sir.
The mediated agreement is a contract. Why do we even look at the policy? I mean, you've got a contract, and the contract says this is the payment that we're going to make. Why do we care about the policy limits? Because if you have a contract saying that you're going to do a specific thing, and you could very well, for good reason, decide I'm going to pay more than the policy limits, because when you take in consideration attorney fees and all of that, it may well exceed policy limits. So we've got a contract that says that you're going to pay 50,000. If you only plan to pay 25 because you were claiming an offset, a credit, I mean, why didn't the agreement just say that? I mean, why hide the ball about it during mediation?
We weren't hiding the ball about it, Your Honor. Mr. Birch is an experienced attorney. He knows as well as anyone that under uninsured motorists, there are certain offsets. Their BI limits were 100,000. The only thing that was ever discussed with me, with Judge Perry, was from the beginning of this case being filed, it was obvious that this was a policy limits case. The Mooreheads had tremendous injuries. Those limits were offered from the beginning. They needed part of that money prior to the case being concluded, and the policy allows for that. It allows for BI to be paid during the pendency of the claim. It also states that the med pay payments are to be deducted, or you receive credit for it. I don't think that, it certainly was not my understanding that there was to be an additional $50,000 paid. I had no authority to agree to anything beyond policy limits, with the insurance policy providing how we arrived at the final amount.
Did you include the language policy limits in the mediated agreement?
No, sir.
Why not?
Judge Perry drafted it. It just set out what each party was to be responsible for. It did not say that the med pay would be waived. Had Mr. Birch wanted that waived, I wish he would have brought it up at the mediation. It could have been addressed, but it wasn't.
So at the time of the mediated agreement, you understood that you weren't going to pay another 50,000. You were going to only pay, a farmer's was going to only pay 25. Is that right?
Per person, yes, sir.
You understood
yes.
You understood it at the time of mediation.
That was the limits. We understood we were going to pay limits.
But what I'm asking you, at the time of mediation, were you aware that the additional payment would only be $25,000?
Additional payment? Yes, sir.
at the time of mediation?
Because 25,000 had been previously advanced.
I understand that, and they understand it now, but I'm just trying to understand, at the time that you mediated the agreement, did you understand that the actual payment was only going to be another $25,000?
Yes, sir.
Okay. But you didn't mention it at all. But you didn't mention it during the mediation.
It wasn't discussed at all by anyone.
And you don't think it was relevant to anything?
In hindsight, absolutely. In hindsight, mediation agreements are going to be much more specific.
Because actually, if they had known that they were going to only get 25, they could have negotiated a higher settlement with the Crabtrees, couldn't they?
Potentially. I don't know if that would have done any good or not. I also question, why didn't they move to set aside the mediation agreement if there was this bad of a mistake, as they're alleging? We could have gone either way. We addressed that in the trial court at the motion hearing. In fact, the judge mentions that in his order. We believe that the terms of the contract, the policy, have been complied with, and we paid everything that we're obligated to.
Anything further, Mr. Nichols?
No, sir.
All right. Mr. Birch, you have 5 minutes for your rebuttal.
Thank you, Your Honor. Mr. Nichols is absolutely correct when he states that the policy has been complied with by Tennessee farmers. But that's not the issue we're here on today. The issue, mediation agreement has been complied with, whether the contract has been complied with. And the contract is clear in this regard. The only thing the contract says with regard to the uninsured motorist company, their obligation states that Tennessee farmers will pay $50,000 to Deborah Moorehead, and Tennessee farmers will pay $50,000 to Jerry Moorehead. That denotes something happening in the future. It doesn't reference anything that had happened in the past. We think it's clear. My clients were satisfied with the mediation agreement at $300,000, and they only received $250,000 of that $300,000 settlement. We're asking the court to reverse the trial court.
Mr. Birch, let me ask you a question. Does the mediation agreement even address insurance? Is insurance even mentioned in the agreement?
It says that the Moorehead's carrier, Tennessee farmers will pay Deborah Moorehead $50,000, and the carrier, Tennessee farmers, will pay Jerry Moorehead $50,000. So if that's what you mean by is insurance mentioned, yes.
But it says it will pay 50. Okay. All right. I understand. All right. Thank you very much. Go ahead.
That's really all I have, Your Honors, unless you have any further questions.
I don't hear any further questions, so thank you very much. Gentlemen, we'll take your matter under advisement and issue an opinion as soon as possible. Thank you for your arguments today.
This Honorable Court of Appeals is in recess until 11 a.m.